Mayor, Your Honor.
Yes.
I beg to mention item number 6.
Item 6.
Yes, Your Honor.
Yes.
May be listed after 2 weeks.
Why?
Actually, here we have to file rejoinder for respond number 2.
On the prayer of Miss MS Tisamo,
Yes, Your Lordship.
Learned Counsel. Your name is not there. Learned Counsel for the Learned Counsel appearing on behalf of Mr.
Esmo.
Esmo, Learned Counsel for the list this matter after 2 weeks.
Much.
My lord, this item may be kindly take along with WPC number 219. The purpose of filing, my lord, is after filing this 219 writ petition, these 2 impugn orders were discovered, my lord. So I cannot improve my case by filing additional affidavit. So only therefore that budget by means of writ petition.
This is the foundation. These orders are the foundation.
One among those foundational.
Yeah. And Mr. Titi Tara, Learned Counsel for the petitioner. Challenge made in this petition is to the communication dated 21/01/2025 and
21/02/2025
by the chief engineer with the then bracket Western John PWD, whereby the executive engineer has been directed to issue fresh tender.
No, till now nothing has been done.
No, why this communication to issue fresh tender?
To follow the GFR.
Huh?
To follow the GFR. General
Yes,
Finance.
GFR includes issuance of
To stop any unauthorized activity
and then to
on
stop
5 nodes of bridges.
unauthorized activities in respect of the construction of 5 numbers of bridges from
On Itanagar Jotero.
at Itanagar Jote Road.
Correct.
Mr. Issue notice returnable by 4 weeks. As Mr. Ratan London, additional senior government, additional advocate general, alters appearance, accept notice on behalf of all the respondents.
All the rest. Yes.
No formal notice made by list along with the list the matter along with WPC
219
of 2025.
Well, kindly status quo.
Huh?
The status quo is already granted in this.
While this entire matter, he was allowed to construct a road.
Having considered that this court has passed an status quo in writ petition 190
219.
219 of 2025 on the subsequent orders, subsequent communication public orders by the chief engineer,
Correct.
Western John,
This was not subsequent, this was prior to
no,
Subsequent filing. Discover was
subsequent of these orders. Huh?
Correct.
The status quo be maintained.
no construction, my lord. No construction.
Huh?
Otherwise, they might carry out.
Status quo means no construction.
Nothing.
My lord, that may be no construction.
We cannot change. There is already
Otherwise, in the guide of
detailed order has been passed to the consequent, the subsequent orders in earlier writ petition. Detailed orders.
yes, my lord.
After 2 weeks.
So we'll not change it.
Since there is no construction
After
going
2
on
weeks.
till now,
After 2 weeks.
no construction is going on. Now,
It's okay, then status quo.
It's status quo. Let us see what. After 2
Ensure
weeks,
that no construction is met.
I shall. After
Ensure that no construction is done.
I shall communicate. After 2 weeks. Good.
Returnable with 2 weeks. Yes.
I know this petition is prepared being agreed by dismantling order issued by the Deputy Commissioner Zero, reserving the power of the state officer. Here, so-called notice was directly issued by Deputy Commissioner, and dismantling order was also issued by Deputy Commissioner.
Lordship, here we have filed our affidavit, Lordship, already. Lordship,
You have
I don't
filed
know if
affidavit.
it's for admission here. So
Additional-
It's already admission. It's already listed for admission. You're not ready.
Next,
Are you admitting that the deputy commissioner has passed the eviction order? Where's your affidavit?
Lordship,
Issue is that, only issue is that the deputy commissioner has issued the eviction order.
Yes, my lord.
Whereas as per the provision, it is the state authority, state officer.
Yes, sir. Moreover, my lord, I was informed by deputy commissioner that land has been transferred in my name, and I was advised to expedite the construction activities of my university.
Have you been given the allotment order?
no, Lordship.
Not allotment order, but I was informed by the letter of the deputy commissioner.
Where it is?
Uh,
Where it is?
my lord, page number 20.
Page 20.
Page number 23, my lord. 23, my lord. I'm sorry. May I read the content, my lord.
You are Indira Gandhi
Yes, my lord.
Technological and Medical Science
University.
University.
Yes, my lord.
Yes.
Now university is full swing, man. It's running there, my lord.
Then the same deputy commissioner has issued the eviction notice.
No, my lord. Different deputy commissioner. Subsequently,
The deputy commissioner may be a
Madam.
different person.
yes, my lord.
But then
On what
Lordship,
ground?
Lordship, no, there is no allotment and then this is government land, Lordship.
I know this is,
Earlier under
see, page 2017, 2023, you are advised to expedite the construction of building for Department of Paramedical and on this was laid on 20th April by the understanding that SSB so that students could be benefited.
Lordship, other than this, there is no document.
Understand, but then they have already constructed on the basis of this letter.
May I please, my lord, for
Lordship.
hearing of the matter.
For allotment, there is a committee, Lordship, committee.
I understand, but
groups.
problem is you
What
have
of procedure is there, Lordship?
deputy commissioner has allowed him to expedite construction.
That I cannot deny the letter, Lordship.
Yes, that's why
But then
accordingly
only on this-
they have constructed.
Only on this, the 4,000, 5,000 square, meter, Lordship. Cannot be, Lordship.
Hearing. Hearing.
Other than this document, they don't have any document, Lordship, showing that it has been, there is a government approval, Lordship. Zero, Lordship, the government land, we have very, Lordship, scarcity is there and then illegal encroachment like this, Lordship.
No, your deputy commissioner has allowed him to construct. Accordingly, they have constructed.
Moreover, my lord, in 2003, when I was initially allowed, then deputy commissioner also recommended, requested the secretary GA for a transfer of the land in my name. It's also there. Next B,
Where it is.
page 19, my lord.
That has been cancelled.
No, my lord.
They've said that it has been cancelled.
Yeah.
They cancelled the transport allotment, so they did 12th April 2018.
Yes, my lord. That is a subsequent, that order. It is, they have said that they have cancelled the order after a year, but, our ground that we have not received that.
What we have said that, till the cancellation lordship time, there was no, construction lordship, no accessible structure or building. When it was cancelled in 2018 lordship.
No, my lord.
Now, we have said that in our statement. My page 5 lordship. Also, what we have said about this letter by the.
Where is
recommend-
that,
That lordship, we have issued it mistakenly, and after lordship. Being aware of the mistake lordship, we have cancelled it in for 2018. Within a year,
Not within, yeah, more than
within
a
a
year.
year, 2018. It was issued in 2017 and
17 January.
cancellation was in 2018.
See the month.
Month.
because of, heard Mr. We'll dispose it off.
Again, my lord. If necessary, they can, I mean, by following a due procedure, they can, my lord, proceed for eviction order. But in this case, main thing that first of all, they have allowed and advised me to.
So we'll direct them to, we'll set aside this order and yes, madam, we'll direct you to take action as per
As
law.
per law, my lord.
Lordship.
Because deputy commissioner is an appellate authority
Yes,
under the law. We'll set aside, but we'll direct you to take initiate actions as per law by following the eviction of unauthorized. So, huh?
Lordship.
fine, my lord.
What do you say?
Also in Ferrite, what we have said is that for any kind of education.
No, we understand.
institution,
There is no allotment. Only a letter by the deputy commissioner which has been subsequently cancelled. That time he has already constructed
we have said that at that point of time, there was no construction.
no construction. After the cancellation, before the
No, after the cancellation, around it. Was cancelled.
2018.
Structure.
Hmm.
That's what we have said.
But that's not correct, my lord. Construction.
Anyway, I'll not go into that. We'll
Yes.
say that state
Yes, my lord.
officer to issue notice and all this thing as per the law.
Yes, as per law, my lord.
Heard Mr. Dilaji, learned counsel for the petitioner. And also heard Mr. G. Learned additional senior government advice for all the respondents.
Yes, Lord.
I'll pass the order.
Apply, my lord.
What remains?
As well as today for the admission hearing,
Hmm.
all the epidemic has been already received.
Hmm.
Now I ready to be take up the matter for
Hmm.
the argument. I ready for that argument for the today for hearing, so my lord. Admission. hearings.
You are ready for
Yes,
the
yeah,
argument.
yeah, yes, my lord.
Argue it.
Yes, my lord. My lord, here is case of that floating of tenders.
Sorry for interruption. My lord, before my friends start arguing, my lord. Now, my lord, as per that recruitment drive, my lord. Now appointment has been already done. Now employee have already joined. They are serving. They are drawing the salaries, my lord. Unless they are employed, can my lord any mandamus or sanction can be issued, my lord, because they will be the most effective.
It's over.
Yes, ma'am.
Appointment and outsource
Yes.
everything over.
In our affidavit, additional affidavit, we have stated that. That is the-
Yes, my lord, here is matter is that,
Learned counsel for the petition.
my lord,
And also had Mr. Arrest Nabam Learned Additional Advocate General for the state respondents. Admit list for hearing in usual course. This is nothing.
my lord,
We are admitting your petition,
yes, my lord,
we are listing it for hearing,
yes, my lord.
right? Because I don't want to dismiss.
Same matter, my 4 and 5. same.
Yes. 4 and 5. 4 and 5, same. Oh, sorry, 3 and 4.
No, Lord.
Three and
I have.
Five.
Five. This is five.
Yes,
My lord, this is relating to eviction order.
so,
My lord, in the previous hearing, this court has directed the respondent, counsel of the respondent to take instruction from the respondent
I
authority
have the
to
instruction.
consider the matter today regarding interim relief.
Lordship, here petitioner is under the inside the compound of district horticulture office, Lordship. Initially, his brother is the handyman of in the Department of Horticulture office. He was staying with the brother, Lordship, this petitioner's husband.
yes.
Inside them, because of the non-existence of quarters, these were built and they were allowed to stay there. Now they have he has been transferred and they have got a quarter also in different place, Lordship. But then the brother has stayed back and he's claiming that place, Lordship.
Well, the fact of the matter is this, that I have been in occupation of this land since 1999. And I have applied for land allotment in the year 2020.
Lordship, this MIP was,
And
MIBT was built in 2017 and 18 only, and they were allowed to stay starting from 2018 only.
well,
So-
the application that I have filed for allotment, that has been sent to the Directorate Office for
This is allotted to horticulture, agriculture.
Horticulture.
horticulture. And
In
my,
the year 2011, it was allotted. Whereas they have been, Lordship may handing up annexure 3 of the petition, page number 22. Their application for allotment.
yes,
Serial number 11. Page number 22. Serial number, since when this area is occupied? 8 years. And this application was filed on
22, 20 years.
and if you come to it's 2012. And this land has already been allotted in the year 2011. Entire land of 25,008 point something square meters. And there the annexure, another annexure, the map they have submitted in the annexure 20, page number 23. Page number 23. This is the land they are claiming, whereas the entire area is of government land. In the middle, they are claiming that this land belongs to them. However, the whole area of 25,000 belongs to the horticulture department.
25,000 square meter.
25,000
Is this in my, this one also?
7,000 and 8.75 square meter.
Yes.
my lord, my land is located outside the allotted area.
Lordship,
Please, please.
At that time, though the infrastructure was small, that's why.
Your map, it clearly shows.
My lord, the nature of the land, the higher side of the land is allotted,
Sorry.
but in the lower side of the land is occupied by me.
Sorry.
My lord, I have applied for land allotment.
I
And
created this kind of.
Just a second. I have applied for land allotment. That
It's a
has been-
government land, it has been already, it's not a vacant land, it has been already allotted to the department.
My lord, the allotment is always
And
given
your
from the
relative
government.
or brother? Father or brother?
Is the brother of the
Her brother or father was working as was the
brother,
employee of the department,
No,
brother,
no.
brother.
brother.
Okay.
My lord, no, that is wrong. My lord, they are talking about
This
my
means-
husband. My lord, they are talking about my husband.
Of course,
Hmm.
we
But
have said
first,
so.
please hear me, then.
There's
you
nothing
don't-
to be heard.
My lord,
Okay, heard Mr. Esquire, London Council for the petitioner.
My lord, I may be hard, then your lordship may pass any order.
What is to be heard?
No, my lord. Page number 23A, my lord.
Ah,
This is the forwarding letter
ah.
by which my application for allotment has been forwarded for government approval.
Doesn't matter.
And then, my lord, it was sent back to the deputy commissioner.
How you
It's-
managed to
it's a-
get it forwarded and how you managed to get it sent, I don't know.
My lord, that has been sent back. to the deputy
Admittedly, it's
commissioner.
a allotted government land. Government land allotted to the department.
My
It's
lord,
a heart of the.
I'm saying it is located outside the
No,
allotted
your
area.
clear page 23 map shows, your map is clearly
My lord,
page 23,
Yes, page 23.
sketch map.
Page 23 is sketch map, my lord.
Huh?
Yes, my lord. And this
Land,
this-
where is your land? I mean, the land claimed by which located. It's a heart of the
my lord, this is a government land I have occupied.
government land allotted to the Department of Horticulture.
My lord, I am saying it is located outside the allotted area of the horticulture department.
Hmm,
And my case was forwarded for approval
hmm,
from the government.
hmm.
And the file has been returned to the deputy commissioner saying that there is some discrepancies.
Heard Mr.
But that
Esquire,
discrepancy is
London
my-
Council for the
That
petitioner.
discrepancy is curable. my lord.
MS G at London Additional Senior Government Advocate and Mr. T. Gets London Standing Council for Horticulture Department have received their respective instructions. Mr. 2 weeks' time is granted to the respondents to file their affidavit. You file an affidavit?
My lord, in the meantime, status quo may be maintained, my lord.
No. Otherwise, I will dispose of the matter today.
How like that? No. No.
It's a clear. Yes, sir. What is to be done
My
today?
lord, first, IA 181 may kindly be taken up.
Where on the,
IA 181.
Your lordship, before when election petition is taken up, your lordship, I have filed two IAs by district election officer. IA
why is for what?
one, IA 187 is for shifting of election materials, that is EVM and BVPATs from Panchayat Hall to strong room of TEO, your lordship.
Let us.
Let me first continue. It's an earlier in point of time. IA 181. You may, let the time comes. My lord,
Sir, if you agree, if you don't, I mean, any objection,
my lord,
can you
as the
can you-
election commission is concerned, it is between.
can we take up this matter on 14th,
Subject to my esteemed colleague.
where,
Let me just
If
see
it
by
is not-
folder, my lord, only.
because, see,
14, I'm yes, my lord. My
Well,
lord, what about 13th, my lord? 13 would be still better.
Milord, if it is 14th, Milord, I would request, Milord, after 15th August, that because after that vacation, that will be
why not, and then 13th? Let us do it on
Could it be on
13th,
18th?
in a new,
18th,
new High
18th?
Court, new High Court building.
Well, 18th?
18, we don't know. Will have to be in Guwahati, I think. Let
I-
us do it on 13th.
13, I'm available.
Yeah.
I'm available, but my esteemed colleague,
13th, Milord. There are actually one arbitration matter, Milord. That's evidence is going on there. 12, 13, 14.
Okay.
That's the problem. Can it be, Milord, 18th, 19th? Okay.
18, 19 also, I can
Or-
make
or-
myself
but-
available.
Or 20,
No, I have a problem because
21st, 21st.
no, the 21st, because Justice Devashish Barua would not give adjournment.
Today, Milord, we will fix the date, Milord. Today, Milord, it's a very limited issue. We can place the evidence also subject to your lordship's order because it has become, the issue is very narrow, Milord. This IA
I'll
has
object.
been
On zero,
argued
I
also
am
by
going to
him,
object.
by me also, because your lordship's last order says that subject to framing of issues, because at that point in time, your lordship said the other side's contention was there may be a speculation, roving proof and all. Then your lordship said in that order that subject to framing of issues and filing of list of witnesses. So once that is done, there is no question of further, the issue is crystallized. So I have two judgments directly on this point. So once issues are framed and list of witnesses are filed, there is no question of roving proof anymore. Because now parties have has taken a stand. Lordship has framed the issues also. So there is no further question of. So therefore, there are two straight judgments, Milord, on that. It's a very. I will take only 10 minutes, Milord. I will just place those judgments.
Then, Milord, I will also argue my point. As
So
to
that
ground
will
on
not
which
take
I'm
much
objecting.
time, and then we can Lordship may fix it on 18th, 19th, whatever convenient, Milord.
Milord,
We will
thereafter-
file our evidence also because,
Then
Milord, it will. What will happen
No,
is
what this IA is 181.
181.
IA is for what?
Milord, 181, Milord, please. It's my IA, my dear friend.
That 181 is that. Milord, I don't object. That may be allowed, Milord. Milord, that
Yes, restructuring of issue number 7. This IA, Milord, is under order 14, rule 5. Because, Milord, Lordship may see issue number 7, internal page 3 of the IA, paragraph 2. The issue number 7, which was framed,
Page.
internal page 3. The issue number 7, I have quoted. The way it was framed. I just read, Milord. Whether there is a denial of assistance of the polling agents to the petitioner and whether same amounts to violation of the provisions of the Act and the rules made thereunder, and therefore the election of the respondent deserves to be set aside under section 101D. Now, Milord, to this, my assertion is paragraph 3, that in page 50, para 33 of the election petition, the petitioner has specifically pleaded about the kidnapping of his polling agents of 16 Pagba, 29 Kambang, and 20 Sangram polling stations. However, the issue framed on the said subject speaks of denial of assistance of polling agents to the petitioner in general terms, making it wide, open, and sweeping. Further result of the election concerning returned candidate getting materially affected by any non-compliance with the provisions of the Constitution or of the provisions of the Constitution or of the representation of the People's Act 1951 or of any rules or orders made under the said act is a ground for declaring an election to be void under section 101D Roman 4 of the 51 Act. But the issue number 7 only refers to section 101D, even though section 101D is subdivided into 4 categories, 1, 2, 3, and 4. And the issue number 7 in question squarely falls under subsection 4 of section 101D of the said act. So, Milord, in that view, the proposal is, Milord, page 5. The restructured issue number 7 now is whether the election petitioner was denied the assistance of his polling agents in 16 Pagba, 29 Kambang, and 20 Sangram polling stations, and as to whether such denial materially affected the outcome of the election of the returned candidate within the meaning of section 101D4 of the RP Act 1951. That is all. This application is under order 14, rule 5.
No, this is an
Because,
amendment.
Amendment
This is an amendment to the
Amendment
issues, Milord.
of the issue.
Milord,
It can be done at any
this can be
stage
added
before
as
the
an
decree.
additional issue. I have no difficulty, Milord. My friend wants to be added this issue. It can be added as a separate issue. There's no problem. Because these are all arising out of the pleadings. So my friend wanted it in a different way. So I have no objection to that because the pleadings are there. I will lead evidence.
We'll amend the issue.
Issue number 7.
Issue number 7.
That can be done. No problem. No difficulty. So on this, I have no objection.
Okay.
Milord, I have the second IA, which is there, Milord. That IA is IA number, which is the
one
main.
by one.
Yes. Lordship will
Dispose it of.
this IA, Milord.
This IA can be disposed of.
Huh.
181. 182, Milord, I will object. I will make my submission.
Mr. Pickett, Tiwari, London Senior Counsel assisted by RL London Counsel for the applicant, respondent 1, respondent.
Yes, sole respondent.
And also heard Mr. Rituraj Biswas and Mr. DG Kapit learned counsel for the opposite party election petitioner. By filing this application, the applicant has spread for amendment of the restructure. Application under order 14 rule 5 of CPC 1908 has spread for amendment of the restructure of the issue number 7 is framed by this court on 20/06/2025. Mr. Tiwari, learned counsel for the learned senior counsel submits that inadvertently while settling the issue, particularly the issue number 7, this court has framed, this honorable court has framed in a manner which makes the said issue wide sweeping and vague. He submits that in paragraph 8, page 8, paragraph 33, Roman 33, small Roman, of the election petition, the election petitioner has pleaded about the kidnapping of his polling agents of 16 Pagba, 29 Kambang and 20 Sangram polling station. However, the issue framed on the said subject speaks of denial of assistance of polling agents to the petitioner in general terms, making it wide open and sweeping. Mr. A further submits that further result of the election concerning a returned candidate getting materially affected by any non-compliance with the provisions of the Constitution or of the Representations of People Act 1951 or any rules or orders made under the said act is a ground for declaring an election to be void under section 100 within bracket 1 bracket close bracket small d bracket close bracket small Roman 4 bracket close of Representation of the People's Act 1951. But the issue number 7 only refers to section 100 within bracket 1 bracket close bracket small d bracket close Therefore, issue number 7 in question squarely falls under subsection 4 of section 101D of the Representations of People's Act. As such, he praised that the issue number 7 may be restructured, public amended. Mr. Rituraj Biswas learned consent with the opposite party of the election petition. Clearly submits that he has no objection for amendment of the issue number 7, as the same might have been inadvertently settled under section 100 within bracket 1 bracket small d bracket close instead of section 101D Roman 4. The people say. Next, having considered the submissions, non consideration on the perusal of the issue number on consideration of the issue number 7, it appears that the same has been inadvertently settled. Listen, in view of the above, I deem it appropriate to amend the issue number 7 as framed by this court. By amendment of the restructure, which is as follows. Page 5. We'll just quote this only. Mr. IA stands allowed and disposed of. Let it be suffice.
Yes, my lord. My lord, IA number 182. Well, this is an IA, my lord, for production of the balance document. Your lordship will recollect, my lord, your lordship has passed an order in June,
Yes.
where your lord, in May, my lord, 19th of May, where lordship has given us access to certain CCTV footage and certain documents.
Yes.
In that, my lord, there was a paragraph where your lordship said ki at this stage, I'm allowing this.
Yes.
Subsequent documents will be considered at an appropriate stage, which is at that time, there was no list of witnesses and issues were not framed. So at that time, your lordship did not. I will take your lordship straight to that paragraph, my lord. That is at page number, paragraph number 43, page number 21 to 45, my lord, at the top of the. Actually, my lord, 43 page number, lordship may come. From there, lordship records all the judgments.
Yes.
That marked copy of the electoral roll can be given, subject to order of the court. And finally, my lord, 43, I'll just read out 43, my lord.
Yes.
Having considered the documents and materials sought to be allowed to inspect and provide copies thereof by the applicant election petitioner, and having been found that the document and serial number so and so covered under 93(1)(a) to (e) of the conduct rules, as well as in the light of the principles laid down by the Honorable Supreme Court, I am of the considered opinion that at this stage, the prayer for a direction to allow to inspect and obtain the aforementioned particular documents and materials prior to filing of the original documents, before framing of issues, and prior to presentation of the list of witnesses would not be necessary and would result in allowing the applicant to make a roving inquiry to fish out material for challenging the election of the opposite party. Now, I'm just posing here, you know, so therefore, at that point in time, because these three things had not happened, so therefore, your lordship did not pass an order on all the documents. Your lordship at para 44 allowed some of the documents. And at 43, lordship said, subject to this, we will again consider. So now these three steps have taken place, my lord. Documents has been filed, whatever original documents, issues have been framed, and list of witnesses have been submitted, my lord. Now, my lord, we have moved this application. Kindly come back to the application. Page number. My lord, it starts at 1. I will take your lordship straight away to page number 11, my lord. Lordship has page 11. Of the same paperwork, my lord. So these are the balance documents, my lord. These are all under 93(1), which can be given to me subject to your lordship's direction. So therefore, my lord, now since these stages have...
These all documents, how many documents?
No, these are mostly marked copy of the electoral roll, my lord, of various polling booth, and 17A, 17C. One thing specifically I'm asking, my lord, that is the postal ballots, my lord. These are all part of the original IA, my lord, where lordship has shown you that 43 and 44, it was there at that point in time also. So finally, my lord, one specific thing I'm asking in addition to what has happened, my lord, your lordship has directed the district election officer to hand me the CCTV footage of 4 polling booths. They have only given me 3. One they have not given me. That is Pagwa. That is 24 Pagwa, my lord. That sorry, 24 row, my lord, that they have not given me. So I'm also asking for a direction, despite your lordship direction, that was not given to me. And these are the documents, my lord. Now the situation has come, my lord, because why, but the difference is, my lord, at that time, my friend's argument was that it will lead to roving probe. Now, my lord, since I have filed my list of witnesses, your lordship has framed the issues, my lord. So everything has crystallized. There is no question of further roving probe here, my lord. And even prior to that, my lord, 17th of March, your lordship, in a striking out pleadings application, your lordship has held that there is sufficient material facts as well as particulars. So therefore, my case is very specific now. There is no reason for him to be misled or for me to lead or me to probe or go into some other issues which is not pleaded, my lord. So now it has come back precisely within that framework, my lord. My learned friend, in reply to this, says that it can be given. They are not saying now it cannot be given. They are admitting these documents can be given.
No,
They are
not
only
given, not given.
just a minute.
Inspect.
Inspect.
Inspect. And they are only saying, my lord, they are only saying ki not now, it is after the evidence is done. So what is happening, my lord? Since I don't have access to this, I have listed 33 witnesses. Once, if I get this, it will be reduced to 6 and 7. The entire trial will be cut short, my lord, because I will not require to bring all the official witnesses or even private witnesses also, my lord. I can cut it short because if I have this, because ultimately, my lord, your lordship will have to see, my lord, whether they are prejudiced or not. If they are not prejudiced, I have pleaded sufficiently with list, annexures, name, photograph, epic number, everything I have given, my lord. Direct to case laws on this, my lord. So one objection is that they cannot be given at this stage. They are saying after. So that is only to delay it, nothing else. Because if I have to lead 33 witnesses, my lord, so that will unnecessarily delay the entire process, my lord. That is one of their objection, my lord. And my lord, secondly, they are saying,
Who has forced you to give 33 witnesses?
no, my lord, since the documents are not with me, therefore I'm saying in abundant precaution, I had to give. I will cut it once I have received it, my lord, I will not lead all the evidence
Better
because
cut it short.
because I will request, I will pray your lordship, and that time with permission of the court, I will reduce it. But since if I have the access of the documents, my lord, it is subject to your lordship's order. Because if I have made out a case, my lord, then your lordship will definitely direct me and allow me to inspection and production. So two judgments, my lord. Because in the earlier round, my lord, your lordship has seen all those judgments. Lordship has quoted my judgments also. But finally, your lordship said, because that point in time, their case was, it will be in breach of the secrecy. So it cannot be. But lordship has rejected that argument. That no, it's not. But at what stage your lordship will decide? My lord, two judgments. One is this Rekha Rana.
Citation.
Yes.
Oh, is there? Refer to me.
ये है सर पहले भी हमने दिया हुआ है
Refer to me, refer.
You any objection?
I have, I'll make 3 submissions. I'll make.
may I just very shortly, my lord, I'll just place it.
1994.
Yes, my lord. So, my lord, I will just take your lordship. First is 2009, that judgment lordship may take. 2009 17 SSC, Rekha Rana. Yes, lordship has.
Pera.
Para, my lord. Yes, my lord, straight away. So, my lord, I will just take your lordship. So, lordship may come to para number 3. I'm just showing the background of facts. Similar allegation. Para 3. It's Justice D.K. Jain's judgment, my lord. It says 96, a similar allegation, my lord. 96 voters cast their vote twice. I am also saying, my lord, the same thing. 29 voters have cast in favor of the appellant by way of impersonation. Same allegation. 53 voters have been cast in favor of the appellant by way of impersonation. Similar allegation. So I'm just, lordship may kindly turn to now 15, para 15. Yes, my lord. Now, in the background of the above submissions, the first question for consideration is to what exactly is the underlying object, scope, and ambit of the doctrine of secrecy of ballot as enshrined in Section 94 of the Act. Section 94 of the Act provides that except in a case of voting by open ballot, no witness or other person shall be required to state for whom he has voted. The underlying object of the provision is to assure a voter that he would not be compelled directly or indirectly by any authority to disclose as to for whom he has voted, or so that he may vote without fear or favor and is free from any apprehension of its disclosure against his will from his own lips. This section confers a privilege on the voter to protect him both in the court when he is tried as a witness and outside the court when he may be questioned about how he voted. This precisely is the principle of secrecy of ballot. 17, my lord, the secrecy of ballot has always been the hallmark of the concept of free and fair election. So very essential in the democratic principles adopted by our polity. It undoubtedly is an indispensable adjunct of free and fair elections. Now, my lord, kindly come to para 22.
Yes.
Having noted the law on the point, the next question requiring adjudication is whether, on facts at hand, the impugned direction infringes the principle of secrecy of ballot and therefore it is bad in law. As already noted above, the case of the election petitioner pleaded in the election petition is that a number of votes had been cast by impersonating electors who were either not available in the constituency on the date of election or had died much prior to the date of election or were serving jail sentences or were abroad on the relevant date. The factum of casting of votes by a particular elector could be proved only on the basis of marked electoral rolls. More so when the names of the votes who were alleged to have double voted or have died, etc., were specifically mentioned in the election petition. Same as ours, my lord. 24. From marked electoral roll, it is only possible to ascertain whether or not a vote has been cast in the name of a voter from a particular polling booth. But it is never possible to decipher therefrom as to whom is the beneficiary of the said vote, as there is no indication on electoral roll showing for whom the voter had cast his vote. It is to be borne in mind that the marked electoral roll is maintained primarily for the purpose of identifying the elector, and as such, we fail to see how its production would impair the secrecy of ballot principle. Accordingly, we reject the contention of the learned counsel of the appellant on this aspect. So therefore, my lord, it's very clear. There's no question of secrecy. Now, 27, my lord. Secrecy of ballot principle presupposes, I'm on 27, my lord. Presupposes the validly cast vote, the sanctity and sacrosanct of which must in all events be preserved. Therefore, we are in complete agreement with the High Court that on the pleadings of the parties, a case for inspection of the marked electoral roll had been made out. We do not find any infirmity in the impugned direction warranting our interference. So therefore, my lord, it's very clear, my lord. Inspection was granted based on identical allegation. The pleadings were same.
Have you named the
Yes, my lord. Photographs. I have not only named it,
voters?
epic number, photographs, everything. All details with comparison from all polling booths. I have given that. My lord, one more para, my lord, para 30 and 31. I will just
31.
30 and 31, both, my lord. Para 30, my lord, middle of that para 30. Nevertheless, Lordship has, nevertheless, if precise allegations of material facts are available on record and the court is satisfied that the inspection of the document is necessary to determine the issue arising for the decision in the case, as also in the interest of justice, then the court must exercise its power under the said rule to allow inspection. Needless to emphasize that recording of reasons in either of the two situations is a prerequisite for exercising of power under the rule. 31. In the instant case, as noted earlier, the election petitioner has specifically mentioned the names of the persons who had been impersonated or had double voted. Moreover, while dealing with the three preliminary issues in its order, it is so and so, the court had recorded a categorical finding. The election petitioner had placed on record sufficient material to substantiate the allegation made in the election petition. In view of the said finding, we do not. My lord. So therefore, my lord, your lordship has also had, my lord, 17th of March, that order.
Next.
Yes. The next judgment, my lord, is 1994 supplementary 2 SCC, my lord, 619. Here, my lord. Party's name is Neela. Party's name?
Neela Lohit Padas.
Yes, my lord.
Another.
Just 1 minute. Nadan versus George Masreen. कॉपी सर को दे दो ना ये है सर,
Nila Lohita Dasan Nagar.
Yes, my lord.
Oh, 94 subject.
Para,
Yes, my lord. Here, my lord, paragraph 10,
only paragraph 10.
my lord, 3 paras. Or
Same.
same, my lord. So I will take your,
Rajbir Singh Gill, Gurcharan Singh Thohra.
yes, my lord. So I will take your lordship straight to my lord, para 13. Lordship, just note para
But by
13.
and large, this is their claim for recount.
So para 13, my lord. The next page, I'm just read out the top from the top, my lord. Para 13 on the next page. Page number 9. Lordship has that in this situation at the top of the page, my lord. Where para 14 starts, above para 14.
Above para 14.
Yes, my lord. Just above para 14. Provided in this situation, it is difficult for us to digest the argument that the High Court proceeded to allow inspection without being satisfied on evidence. Lordship has that even in the form of affidavit that it was necessary to allow inspection in the interest of justice, since the names of the voters were alleged to have been voted had specifically been pleaded in the election petition and the recrimination petition. It was necessary to correlate their name with the electoral rolls and the counterfoils of the.
Which para you have
My
pleaded?
lord, it is in page 9. Just
No, which para you have pleaded? The names of the.
yes, my lord.
Voters.
Straight, my lord. Yes, my lord. Lordship will have my main petition, my lord. There is an annexure, complete annexure, my lord. So it is page number 445 to 551. So this is annexure 27.
Paragraph,
20 paragraph, my lord, yes.
annexure?
Annexure 27, my lord.
Numbers are given below. Total how many?
And the paragraph, my lord, on this is from paragraph Roman 26 onwards.
It's okay. Then
Yes, my lord.
next para.
So that is the paragraph, my lord. Details are given and it has been annexed also, the names and details, because it's a huge list, my lord. I could not have pleaded each and every name in the petition. So I have annexed it and I have marked it in the petition.
Have you named it?
Yes, my lord. Kindly
In the paragraph?
in the paragraph itself, my lord, I have.
Names are given?
Yes, annexure
In the
given.
paragraph?
Yeah, not in the paragraph. I have stated that it's a large number of names. So therefore, I'm annexing it along with the annexure. It should be treated part and parcel of my pleadings. I've stated so.
That's all.
So, my lord, now, my lord, I have shown the 2 judgments, my lord. These judgments are precisely on this point, my lord. So therefore, my lord, the stages is over, my lord. Now there is no question of roving probe or anything, and it will help the trial. My lord, that judgment, the last judgment, it records. I will just give the paragraph. That it says, you know, that will help to expedite the trial. That is also one of the reasons. If the other side is not prejudiced, that should be done, my lord. That is the crux of the matter, my lord. One last paragraph, my lord, from that judgment. Para 14 also, my lord. Joshua, may kindly have a note. 14, para 14.
Then.
My lord, para 14 only, my lord. That's the crux. I'm not reading out, my lord. I'm.
Yes.
Yes, yes.
Oh, very good. Very short submissions, my lord.
Yes.
My lord, my first submission is in respect of the clear mandate of Rule 93 of the conduct of election rules. Because, my lord, the prayer is not only the inspection, it is also the procurement. They want to have the authenticated copies of those documents. Now, my lord, Rule 93, Lordship may
You have
kindly
filed
take.
an objection.
Yes,
Yes.
I filed my objection.
This is the objection.
Objection is there, my lord, in the,
One
it was filed yesterday.
Objection. Must be here. 183.
In my objection, my lord,
So one.
objection of respondent against the relief sought for. It is headed like this. Objection of respondent against the relief sought for in IA, civil such as such, 182. The heading itself is there
180.
on top.
This is the,
Objection in 182.
Milord, I just point out, Milord,
Let's talk about it.
Roman para 28 is the annexure 27 which has been annexed. In my main petition, it is
28.
para 28, Roman para 28. I've specifically said the names are not extracted in the body of the pleadings. However, the same are considered to be part of the pleadings. That is there.
182.
Lordship, may I have this?
The copy we have given, extra copy we have given. You have, no, the copy is here. You can take extra copy from us
Ah.
instead of shuffling the papers.
Somewhere.
We will take it. It was filed yesterday. Has to be there. But anyway, you take the copy.
Why not?
Now, my lord, the first submission I'm making is in respect of Rule 93 of the Conduct of Election Rules 1961. This submission, my lord, will find in paragraph 12 of my objection. I read the paragraph 12 itself. This is my first submission.
Yes.
I read paragraph 12
Hmm.
that it is pertinent to mention that Rule 93 Sub-Rule 1 of the Conduct of Election Rules 1961 mandates only inspection and production of the documents mentioned in Rule 93 1A to E under the order of a competent court. Whereas in the case of other documents, Rule 93 Sub-Rule 2 mandates that subject to such condition and to the payment of such fee as the Election Commission may direct, quote unquote, all other papers relating to the election shall be open to public inspection and copies thereof on application shall be furnished. Hence, there is a clear distinction between inspection, production of documents mentioned in Rule 93 1A to E under the order of a competent court and other documents covered under Rule 93 Sub-Rule 2, which shall be open to public inspection and copies of which may be furnished on application. So, my lord, my first submission is they can inspect and the documents can be produced before the Honorable Court, where they can inspect it, but they cannot take the authenticated copies of such documents. Although all that which is covered by 93 Rule 1, A to E, the rule doesn't provide for it, making a clear distinction between the two. My first submission. They can inspect and documents can be produced on the basis of which they can inspect.
They can inspect, but
They cannot obtain the copies of the same.
so according to you, it has to be produced here
Yeah,
and
before
in-
the-
before the
yes.
court,
Yes.
before the court, and they can inspect.
Yes.
And they
And
can
it will be-
obtain.
It will naturally be produced, my lord, by the competent authority, which is the custodian of those very documents.
Hmm.
And my lord, in their case, the 33 witnesses they have named, those very officials are also the named witnesses. So once they come before the court, they will bring with themselves the documents. They can very well inspect it and they can take their notes.
So they-
Let me complete my argument.
I think, sir, they are not seeking for obtaining copies.
They are, my lord, the
Milord,
procure.
They are only for inspection.
My lord, they are
Inspection,
also
Milord.
seeking copies. The prayer is
What is
there.
happening, Lord? Because what will happen, I will inspect, I will get certified copies, original will be brought before this court by the official witness. So what is happening, my lord? If this exercise is done, I don't have to call 13 official witnesses. Because then only the deputy the district election officer
So
can
you
come.
want to obtain the copies
Copies,
also?
Milord.
Okay.
So, my lord, the rule doesn't provide for obtaining the certified copies of these documents. It can only be inspected after
Okay.
production.
So inspection, no objection, even not before this court.
Yes,
They
certainly
can
not.
inspect in the election office also.
They can inspect even before the honorable court. They can inspect in the election office, either
But
way.
in no case, they cannot
But-
obtain the.
Since, my lord, the language is production of the documents by the order of the competent court. Production has to be before the honorable court. And therefore, my lord, documents can be inspected before the honorable court. That's my first submission in terms of the mandate of the Rule 93, 1A to E, which makes
It
a
has to
distinction.
be produced before the court
Yes,
and may be allowed to
yes.
inspect.
That's first part. Now the question arises, my lord, at what stage? Now the stage. Now, my lord, so far as the judgment of my lord is concerned, my lord certainly did not, my lord, in the passing, say, let these stages be over. But my lord did not specifically say that it is specifically at this stage that those documents will be produced. My lord did not say that.
In fact, I have
come to-
agreed your, I have accepted your submission.
Yes, yes.
In the,
So
in
now,
that
my lord,
order
my submission is,
that at that stage
yes,
would not
yes,
have.
yes. So, my lord, now my submission on the second point is, indeed, my lord, my esteemed colleague has advanced a very attractive argument that if he is allowed to look into these very documents, inspect these very documents, then the proceedings can be cut short. Indeed, a very attractive argument.
Obviously, you don't want that
But-
proceedings should not be
But
cut
let
short.
us, no, my lord, I'll put it. No, there is, my lord, there is a catch here. Let us put it, let us look at it the other way around. First part is very attractive.
Bente's point of view.
Yes, no, my lord, there are, in this list of witnesses, there are two categories of witnesses. From witness number 1 to witness number 20, total 20 to 21 witnesses are the private witnesses. In their case, my lord, under Order 18, Rule 4, the evidence has to be filed on affidavit by examination in chief, as per the CPC. The examination chief will be by way of an affidavit. Since they are his witnesses, their affidavit will be prepared, evidence in the form of an affidavit will be prepared and filed before the honorable court. On the basis of that, I will do the cross-examination. So far as the official witnesses are concerned, in their case, may not quite natural, their evidence cannot be filed by way of an affidavit. They will come before the honorable court and their examination in chief has to be done before the honorable court. Now, my lord, what happens? I ask myself a question because their allegations are manifold. One allegation is so many are dead. Now, my lord, how do you prove that they are dead? Names are there, yes, but person may also be alive. The counter will be he's alive. Evidence has to be led. Evidence cannot be ruled out. What happens is, my lord, if you do not file evidence on affidavit of your witnesses, and before that, you are allowed to look into the documents, you get a clear and undue advantage over the respondent because you will look into who are these people, who had voted, who had not voted, you segregate, you do your own things, thereafter you file evidence, you bring your witnesses, you say certain things on evidence, on oath, which tallies with the document that you see over there. Now, my lord, I ask myself, how do I judge the credibility of their witnesses? The best way to judge the credibility of the private witness would be as to what do they state on oath in affidavit. If there is a clear discrepancy in their statement on oath, in evidence, in their examination in chief, and the documents, they will be called out before the honorable court. So, my lord, argument looks attractive. Look, it will be cut short. It won't be cut short that way. Dead voters, bogus voters, these are the people, they don't even live here, they live outside. You have to lead evidence. Now, the moment you see all these things, you come to know who are the people who voted. You identify them by name, you identify them by faces, then you lead a particular type of evidence by filing examination chief on affidavit. So that is my point. I only submit under Order 18, Rule 4, you file evidence on affidavit of your private witnesses. Thereafter, you call for these documents, materials, everything. You inspect. Those official witnesses will come. It will be produced before the honorable court. You inspect. And on the basis of that, you do the examination in chief of the official witnesses. I do not want them to get any undue advantage of filing examination in chief on affidavit after perusal of these documents. That will give them clear undue advantage. And my lord, this is what I have mentioned in my objection very clearly. In my objection, my lord, I have stated, lordship will see the paragraphs. Para 14 of my objection,
14.
1-4, my lord.
4.
I read that if the election petitioner is
Yes,
allowed to
I have-
inspect,
I have read.
yes. So this is what it is. Now, my lord, I come to the judgment in the Rekharana.
Right.
Yes. Now, my lord, there are certain portions of Rekharana which, my lord may be pleased to consider. Paragraph.
Citation.
2009.
Rekharana, yo,
Same.
judgment.
You are reading same judgment.
Yes. In Rekharana, my lord, the Honorable Court did something more before allowing them. Something which has not been done in this case so far. Paragraph 7, Rekharana, briefly taking note of the evidence already led by the election petitioner, the High Court has observed in the ensuing order that in the election petition, the election petitioner has expressed the basis of his claim to the minutest details in terms of the provisions of the Representation of People's Act 1951, as well as the conduct of election rules 1961. The pleadings are supported by an affidavit in consonance with Rule 94 capital A of the rules. The evidence recorded on behalf of the election petitioner so far is in consonance with the pleadings. The evidence recorded on behalf of the election petitioner so far is in consonance with the pleadings, and therefore it is not a case where the election petitioner is intending to have a roving inquiry as to fish out material for raising a challenge to the election of the appellant. Then further, the High Court felt, para 8, that the ultimate truth in respect of clear allegations labeled by the election petitioner. So paragraph 7. So, my lord, there was something more in the Rekharana. But, my lord, be that as it may, I submit every case stands on its own footing. Here there is a peculiarity. The allegations of bogus voters, non-existent voters, the voters who are dead, my lord, a degree of evidence is required to be adduced before the Honorable Court. And I do not want his private witnesses to get a clear, decisive advantage of having perused the documents and then file examination in chief. That would be unavoidable. So, my lord, that advantage should not be given, because I would be prejudiced in that case. I will be denied the opportunity of testing the credibility of these witnesses of the election petitioner. So, my lord, let them file examination in chief on affidavit of the private witnesses at least. Then, my lord, all these materials may come before the Honorable Court. They can inspect it. Like Rekharana, it can be done. I have no difficulty. Only this much. So, my lord, let examination in chief of their witnesses be filed before the Honorable Court, and thereafter, my lord, they can very well call for these documents, materials, everything, with the help of the official witnesses. They can inspect it, they can peruse it. Then, my lord, at least there would be level playing field. They would not get any undue advantage over the returned candidate. And I would be able to test the credibility of their witnesses, their private witnesses, because a degree of evidence would be required to be adduced in any case. Only by looking at the name, we can't figure out who's dead, who's non-existent, who lives here, who doesn't live there. It's not possible.
Just to identical argument was led by this the same judgment 1994 supply 2 para 14 by Mr. Prashant Bhushan, identical that this is not sufficient.
Para 14.
Para 14. So I'll just read that. That will clear, Miller. Lordship has that. The second judgment, Miller, 1994 supply 2 619. So both the issues are settled here, Milord. Trial, quicker trial, Milord. So I'll take up quicker trial first, Milord. That is just above para 14, 10 line from the first paragraph, Milord, in the same page. Before para 14, it is for that purpose, Lordship has that. It is for that purpose that the court, in the interest of justice, 10th line from the bottom, Milord.
Yes.
Yes, Milord. So it is on a quick trial, my lord. It is for that purpose that the court, in the interest of justice, to facilitate a quick trial, permitted the parties to inspect beforehand the records, but after the framing of the requisite issues arising from the pleadings of the parties and not earlier. This approach could not be termed as permitting a roving or fishing inquiry, as it is sometimes described in a cases of a claim of recount. We are thus of the view that the High Court committed no error in permitting such inspection in the facts and circumstances of the case. So therefore, my lord, it's very clear, my lord, when it is specifically pleaded names, I can show that annexure 27, my lord, even the photographs are there. There's no question of, that they've been misled. So I cannot go beyond that, annexure 27. So here also, my lord,
Inspection, he is not objecting, only copies.
my lord, copies,
Objecting to the copies only.
my lord,
Inspection after filing of the examination in chief by way of an affidavit of their witnesses.
why, my lord, he is saying he will be prejudiced. Now, para 14. Identical argument, my lord, rejected by Supreme Court. Another argument put forth by Mr. Prashant Bhushan was that the pleadings in the election petitions were insufficient to justify inspection in as much as, except for mentioning that there had been double voting by 19%, nothing else was stated about the basis on which the election petitioner came to the conclusion that these names, which apparently had appeared twice in the electoral roll, belonged to one and the same person, and that those persons had in fact voted twice. Similar allegation, similar apprehension by them. It was also commented that no material facts in the form of affidavits by a single person or polling agents alleging that they had seen, heard about those persons having voted twice was filed in support of the petition. It is maintained that that in the absence of evidence of these particulars being pleaded as to the source of knowledge of double voting, it was dangerous to allow inquiring into such an allegation on the bare allegation of double registration of votes and possible double voting. So specific case, my lord, similar. Now finding, we have pondered over this matter, but regretfully do not accept the argument of the learned counsel. If a name has been registered twice, enabling a person to take advantage of voting in two different polling stations, Section 62 mandates that if he polls both these votes, then both votes are void. A void vote cast is a void ab initio. In the nature of things, the void taint in the election would have to be traced to the election papers, for without the bare oral evidence would be of no use, and at best it would be a word against word, making application of Section 62 welding impossible. If the election petitioner on some information or material or otherwise is able to ascertain that the belief that a particular voter double registered is known to have voted twice, he can certainly plead to that fact on his own entertained belief and need not ordinarily resort to giving details of the source of his information or knowledge or the entertainment of his belief, because registration of double vote is itself the starting point. The exercise of both votes being the second. The election petitioner had specifically mentioned and in clear-cut terms that 19% have double voted. The question was not resolute merely on the oral evidence, whether they had or had not, except to put those persons into the witness box, hear their version and confront them with the election papers. So, my lord, unless I have the papers, my lord, I have pleaded whatever was there in my knowledge. Now, my friend wants you give extra, which you do not know. My lord, unless the papers are with me, how can I, place them before the witnesses? And it will help to cut short the entire trial, which he doesn't want. Because inspection, my lord, because the word, my lord, inspection, if I'm not given a copy, my lord, only inspection will not help anything, my lord. It will not help the progress, because it has to be election inspection with the copy. Otherwise, it is meaningless, my lord. The inspection will be meaningless.
There's 93 provides inspection with the copies.
My lord, it says, my lord, if I go back to the,
Will allow you to inspect, but no copy.
my lord, otherwise, my lord, if copy is not given, my lord, then it will,
No inspection, you can.
my lord, the
No,
problem
there
is,
no
my lord,
judgment. There is no judgment saying that they can procure the copies.
my lord,
No judgment.
I will have to call all the witnesses, official witnesses, my lord. That will cut short the trial, my lord, if it is, I'm permitted to have copies, my lord, because I'm not getting the original copy. I'm only getting a certified copy. And original copy will be summoned.
93 doesn't provide.
So original copy will be summoned, but
Is
then
that-
only through the district election
What
officer.
93 says?
93, my lord, says,
Production,
Only production.
inspection, production.
my lord, it says, inspection, it is for the purpose that the court in the interest of justice to facilitate quick trial permitted the parties to inspect beforehand the records, but after framing of the issues.
And the cases which you have referred,
Yes,
it doesn't talk about the furnishing of the copies. It only talks about inspection only.
my lord, my,
We cannot
but-
say that inspection includes furnishing of a copy.
my lord, normally, my lord, if
These are two
my
different things.
humble submission would be, my lord, to that effect, my lord, any inspection of government records, my lord.
See,
Huh.
why you need an inspection if you want the copy?
Yes.
You could have, obtained the copy, it could have been. You
Uh,
pray for, furnishing of the copy only,
Yes, my lord.
copies.
My lord, kindly have 93.
So the 93 says that inspection and production.
My lord, 93 also says, my lord, that kindly have 93, my lord. I'll just take your lordship to rule 93.
It depends on rule 93.
Yes, my lord.
Representation.
Because- Kindly have 93
RP Act 51.
rules, my lord. It is the rule of
What is the rules? Is it not in there?
1961 rules.
Is it not here? Must be here.
Must be there, my lord. Huh.
It is here in the.
Yes, it's here. This amendment.
Conduct of election rules 1961. my lord.
Yes, it's here.
My lord, it kindly see.
93.
Yes.
Yes.
So 93 subsection 1.
Hmm.
So
Yes.
while in the custody of the district election officer, or as the case may be, the returning officer. So these are the documents, my lord, A, B, C, D,
Shall not be open. The contents
shall not be opened, and their contents shall not be inspected by or produced before any person or authority except under the order of the competent court. So it does not limit your lordship's power to direct them to give me a copy.
No.
Because it's very clear. Let me interpret.
Shall not be opened and their contents shall not be inspected.
By or produced.
Before any person or.
So it
authority
says
except
inspection
under
by or produced before any person with the consent of this court, with the direction of this court. It can be inspected and contents produced also. So it is very clear, my lord, the rule is specific. Inspection and production, both is possible.
That's all.
So
No
I can be
copies,
given,
No copies.
I can be given a product.
Go by the
And clear distinction, my lord.
literal meaning of the.
And rule
by-
two
by-
provides,
go by
and
literal
rule two provides for giving of the copies in
Well,
respect of other documents.
Yeah.
Lawmakers'
These are
intention is very
the
clear.
documents which you have sought for inspection
Yes,
is rule this.
yes,
other- One.
1A to
A to E,
E.
covered by A to
Covered
E
by-
only.
That is
So it's very
covered.
clear.
My lord, I am saying that it doesn't
Then to
restrict your
requirement
lordship
such
power
as
to.
Subject to such condition, commission may direct all papers relating to this shall be open to public, and copies thereof shall be, it's clear. There's a
Ah,
clear distinction.
Other papers.
Yes.
Very
So, my
clear.
lord,
Under rule two,
Ah.
sub rule two,
yes.
copies can be.
That says
That
specifically
may not-
Yes,
that
yes.
may not already
It
directed.
clearly says that
furnished. The difference is furnished. Here it is says because
copies thereof shall on application be furnished.
furnished. So here it says, my lord, that produced before.
That's all.
So
Produced, production can be done. You are not
So-
asking for production, you are asking for inspection.
It-
We'll allow you to inspect,
very well,
we may allow you to inspect
very well.
at best.
Yeah, inspection. So
but-
lordship, my learned friends no
Copies
objection to
to,
that.
no.
But
But you
what
hear that
why not
objection that
consider-
before the,
No, but that I have read out,
that is okay. What I'm saying.
Yes,
In any case, copies will not allow.
yes.
So for the inspection, whether it is the right stage,
That
as
will
he has objected to it, I will
Will
look
also
at
decide.
to it.
will record by submission. on that.
Clear is, will not allow to obtain the copy.
furnishing copy. That very,
Inspection, we'll see.
will do
whether
that.
it can be permissible.
But my lord will record by submission on that.
I'll
Very
copy everything.
Sorry.
Or my lord,
So,
this records also may be called before, because my learned friend today, my lord, she's appealing for the election commission now. So
Where-
they wants to shift it. That's the application basically to
Where
the
is it?
strong room.
Where it is?
So
There's no
what I'm
application.
saying, my lord, that can be summoned before this court also. I may inspect it there.
Where's the application? There's no application. You have filed today. We'll take it up next.
This listed today, Your Lordship. IA number 186 and 87, Your Lordship. IA number 186 and 87. Since DO is not a party, so we have prayed for implementing ourselves. That is IA number 186 for implement. And 187 is for shifting of EVMs and VPPATs, Your Lordship, because
So
DO
whatever
has,
they, are you objecting?
I
Impleted?
have nothing to say. It's EVMs. I have nothing
No,
to say.
number one, they want to, EO, what's this? Election,
district election officer, Your Lordship.
EO wants to get himself impleted.
My lord, I have no objection to that.
The act itself.
At bar said,
It says that only the election, parties to the election can be party to the election petition. So even without
on
including
this,
them.
just to correct
Ah.
this, our, my lord, these days Supreme Court is doing very big things. On this issue also, I think then Chief Justice, Justice Sanjeev Khanna even issued notice and stayed the order of the High Court. Because I think the prayer was made to implement election commission. The High Court rejected the prayer. SLP was moved before the Supreme Court. SLP was entertained, notices issued, and I think certain directions were given in that case. Ordinarily, but my esteemed colleague is right. The law is right. The law, as we understand, is that
As per the RP Act.
only, yes.
Within the order can be passed,
Yes,
allowing them, that's what I'm saying, because it can be resolved without.
That way, yes,
going
yes.
against the-
Yes, I have no.
then only 187 order may be passed, Your Lordship.
Okay, 87, let me see.
87,
Only-
IA number 187, Your Lordship.
Then in that case, you withdraw 186.
Yes, Your Lordship.
If you agree.
Yes, Your Lordship.
There's no wrong, there's not many,
Yes, yes, yes.
would it be appropriate?
I beg your pardon?
Without they being a party, can we pass order?
Should not be ordinarily, this is not correct. Procedurally, may not, this will not be correct.
Because they are not party, how they can file an
Yes,
application?
yes,
to do that?
yes.
Only because
So-
of that, we have filed for implement.
Oh, for that
For the
purpose,
purpose
my lord
of-
can do it. My lord can do it. I would submit, my lord can do it.
The second-
Because, my lord, this is an issue which even Supreme Court is in session of it. So my lord can do it, and we are not objecting to it either way.
Without impeding, Lordship may take notice of the impediment application rejected, saying, but Lordship may allow them to shift, that is, I'm saying, because they are only bothered about shifting from Panchayat office, strong room, to their strong
District
room.
election.
No, in that case, you withdraw both this writ petition, both this IA will pass the order in that thing.
But my lord, since
Or what
ultimately
you
it is on the
suggest?
prayer, we have not
Because
made such
the
a
law
prayer.
doesn't permit for implement of the officer.
It doesn't.
How can
The law doesn't permit. In Jyoti Basu's case, this is the law laid down by the
In
Supreme
that
Court.
case, how can we pass an order on an application who is not a party?
In similar case, Your Lordship, in other election petition also, we have
Their
Fine.
party there.
no, Your Lordship, in where election, DO is not a party. We made 2 applications for implement as well as for
That was
shifting.
allowed.
That implement was not taken up, only shifting, they have passed
Very well,
order,
lordship
Your
may do
Lordship.
it that way.
That can be done, Your Lordship.
In which we before us, they file and.
My lord, it's
For
a,
any-
since election commission is an institution by itself, it is for administrative reasons
why
and
I'm saying that?
logistical
Because your
reasons.
Lordship order on 22nd of August 2024, by which Lordship has taken control of this materials. So therefore, Lordship has the jurisdiction, because question is now today by the election commission that this materials they want to shift to a different place. So since there is an already an order of
Where
the,
is that order?
that 22nd, in my IA also it is there, my lord.
Earlier they had filed IA.
This IA.
IA, yes, at page number.
This
my-
present IA.
IA I have file, my lord, 180, IA number 182,
No, that's what I'm saying. It's present IA.
present IA,
Which
which we have
one?
argued, my lord.
Yes.
182, page number 19. So this is the order, my lord,
Page number
919,
9.
starts from 20, the operating part. So my lordship has that 22nd of August.
19.
Top of the page.
129.
Yes, 22nd of August 2024 is the order. Yes, my lord, here your lordship has directed them, having considered the documents which have been prayed for production, lordship has directed, this is an order, is directed that the district election officer, returning officer shall preserve the following documents. So lordship, and the documents are mentioned here. They only want to shift these documents, material, to a different strong room. So lordship is already seized of the matter. Lordship has taken judicial conscience of these documents and directed them to
So, now-
preserve it. So
perhaps-
Huh.
Which,
So,
which,
I suggest a via media.
which application will pass that order?
no,
My
not
lord,
the main matter. your
I'm
lordship.
suggesting a via media. My lord, the best way would be, my lord may take note of the prayer made by the Council of Election Commission. Lordship may observe, though they are not a party,
Yes.
but such a prayer has been made, to which my lord, both the parties, contesting parties are not objecting to. So for administrative reasons and for logistical, for the convenience, for logistical purposes and administrative convenience, Election Commission is permitted to shift such and such. That's all.
That's all, in view of
That
this
can-
order.
In IA.
Yes. In
the main petition.
Here also. Lordship may pass general order,
Main petition.
either the main
Main
petition.
petition.
Yeah, main petition, election
I think
petition.
that would be better.
Better.
Yes.
In the main.
Election petition.
Election petition 1 of
Ah.
2024,
Ah.
that order has been passed, your lordship.
Huh?
Election petition number 1 of 2024, Kampudolo versus Haing Mangfi. That order has been passed. by
She's talking
Judge
without-
Eviction.
Without impleading.
Yes, your lordship.
No, we'll pass this order. I have noted that we'll pass this order in the
my lord
election
may pass.
petition.
Yes.
Election petition.
Yes, election petition, my lord may pass.
Application. We don't know.
Because possibly, my lord, the catch is, I don't know. It seems, my lord, they have not given that part where the voter can be identified.
Corrupted. But then, when your lordship's direction was there from the last law.
We'll see. You file an application.
Because that is there, in this application only I have mentioned that.
Which
that
one?
The application 182, today's application, I have mentioned that they have not.
You have
given-
prayed for all.
Yes.
In this, we'll consider.
A fresh direction may be given, to give me.
We'll see.
Ah.
Have you mentioned in the application?
Yes, I've mentioned. Paragraph I mentioned. I will just tell you.
It's been corrupted because therefore they could not.
They are saying so, because there should be multiple device below, because this is a very important, because from day one we are
What do you
saying.
say?
My lord, I don't know what exactly the stage is. Which part has not been given to them of CCTV footage? If it is that part where voter can be identified, casting his vote, then possibly there are reasons for that. So we don't know exactly.
No, they have
There is-
given three, one they have not given, your lordship's direction was give them four, because four police station were saying, who capturing a second. Three they have given, one that letter they say is in Marathi. But when we are saying from day one before election, that these are the four, only four we suspect. So they should have preserved it. If they're not, and there must be a way of recovering it. Now today, forensic, this thing is there, everything is recoverable.
We'll see.
What direction to them?
Hard, Mr. In IA, 182, huh? Vishwas and counsel for the Vishwas counsel for the applicant election petition.
You will give notice to
And
for shifting, before shifting. That will be done.
Executive Learner Senior Counsel assisted by RL Sunwan. Respondent. First out. On next date, I'll deliver the order on next date.
Because your lordship urgency is.
In the election petition, main election. Hard sense, huh? Same.
Fix it in after 15, any day.
Yes, we'll fix it. We'll fix the main petition, huh? Same hard sense. Petition, election petition and this sense correspondent. No. The MS
And
in Anju, consist, stating concept for election,
yes, Your-
election commission.
How about 28?
Appearing on, has submitted that the election officer,
district election officer. Yeah.
district election officer may be allowed to shift all the electronic voting machines, EVMs, machines within bracket EVMs, oblique BBPATs of entire field within the ST assembly constituency from the Panchayat office building, colony, which is being used as a strong room for storing election materials to a strong room public warehouse within the premises of the office of the district election officer, Colonia, Arunachal Pradesh. For further use and for further use as per instruction of the Election Commission of India. Mr. I mean, consider that the EVMs, BBPH, and the no, the electronic voting machines and the election materials are permitted to use further as per the instruction of Election Commission of India, and the prayer for shifting of the same is not objected to by learned counsel for the parties. It is permitted that the electronic voting machines, EVM, so and so, same, may be shifted. And all the electronic voting machine, EVM, BBPS, so and so, they were shifted from the Panchayat office building, same, following on so and so, so and so. You just take it from IA 87.
Okay.
You withdraw this,
Yes,
what this thing,
I 186.
186
Yes.
and 187.
Withdraw.
You withdraw. MS so and so, so and so. Press for withdrawal of the utility application.
Okay.
Was on withdrawal. When next date? Yeah,
20.
I don't know.
20.
Election thing.
3 दिन का
List
time
the
से
matter.
होगा, 3 days. 28, 28,
28.
Thursday.
28th of August.
28.
But we don't know whether he'll be or there.
My lord, I'll be here. Next week, my lord, I'll be in Delhi actually. My lord, because my nephew had a neurosurgery, there are complications.
Next week you are
I'll be in
invited.
Delhi, my lord.
No, next week you are invited.
My lord, true, my lord, but
You are invited
my nephew is an ICU, my lord. He
Next
had a
week
neurosurgery.
on 10th.
I know, my lord, but then there are compulsions.
Although the officially card has not
May
been
not be,
distributed.
I know that.
You will be
Unfortunately,
invited. You
my
will
lord,
be
this
invited.
is a family emergency
Okay.
because his condition is not good
Okay.
after neurosurgery. I have to be there.
28th August,
Yes,
right?
sir. Yes.
Okay. 9. Yes. Anita Das. Nobody appears. Non appears for the parties list. After 3 weeks.
Your Honor, I'm for the respondent 1 and 2.
Who is for appellant? Appellant,
They have asked for the LCR.
huh?
They have asked for the LCR in the,
No, this case is listed for mediation.
yes, mediation.
So
Yes, I will accept forward for the mediation.
what about the appellant?
I don't know. They didn't inform.
Huh?
I didn't get any information. There's no direction.
You inform? Can you inform him?
Okay.
Will it next week? Mr. Non appears for the appellant. Mr.
Tita,
T. Tata, learned counsel for the respondent is present. Mr. Since the matter is listed for listed for mediation, listed for referral to mediation. Come on, Mr. T. Tata, learned counsel for the respondent to inform the learned counsel for the appellant. List the matter next week. After a week, huh?
most obliged.
Non appears, huh? Matter listed for a referral to the special for mediation. List issue notice to the parties. List after 2 weeks. Criminal petition.
Husband has been convicted under section 498A.
No, this is the matter is listed for mediation. Referral to mediation.
Between the parties.
Who is for the PP? Who is PP? Where is PP?
Talking to some.
Can it be sent to the mediation? Between, not between the parties, by the petitioners, not with the state. So,
They also agree. As far as they say.
no, we'll send it for mediation in that case. You just call him, inform him. Huh? Then next. Yeah.
We may be allowed to withdraw this petition as the matter has been resolved between the parties.
Item 13.
Yes.
And Mr.
W. Tinkhatra.
Your name, please.
W. Tinkhatra.
WT
Tinkhatra.
Tinkatra,
Yes.
Land Council, appearing on behalf of
Tidon.
Mr. T. Land Council for the petitioner. Submits that he has an instruction to withdraw this petition. List accordingly. And then therefore praise that matter may be allowed to, therefore the instruction to withdraw this petition. List. Accordingly, criminal revision petition stands closed on withdrawal.
Obliged.
Same. What is this? IA. What is IA? Matter is listed for reference to mediation. Non-appeals for the parties. List. Issued notice, huh? List after 2 weeks. Yes.
Mayor, Your Honor, I want to withdraw my application, Your Honor. As Your Honor, sections compoundable in nature, that's why.
Criminal petition.
Yes, Your Honor.
Withdrawing.
Yes, Your
It's
Honor.
not maintainable, my lord, because offense are compoundable.
Heard Mr. Huh?
Yes, Nabum, Your Honor.
S.
Nabum.
Nabum.
Yes, Your Honor. NABUM, Nabum, sir.
S. Nabum, Learned Council. Appearing, your name is not there.
Your Honor, Deon Wakalatama. My name is Deon Wakalatama here.
It's there.
Yes, Your Honor.
Learned Council for the petition submits that he may be allowed to withdraw this. We do the criminal petition. Mr. So-and-so, so-and-so. Then this will be peace present. Accordingly, the prayer is accepted, prayer is allowed, accordingly, the criminal petition states closed on withdrawal.
Much of this.
Well,
Well. So, mediation.
my lord, mediation is not required in this case, since they have already settled the matter, man. So mediation is required when, your lordship, the conflict is yet to be settled by the mediator before the mediation center. But now in this case, your lordship, they have approached this court by settling the dispute, mutually settle the dispute, man. It's a joint petition, man.
No, therefore you are the one. It's not between them. You are the respondent here.
Yes, your lordship. Yes, for the state, your lordship.
Yes.
Yes, your lordship.
You are for the state. It
Yes.
will be between the state and you. Them.
Yes, your lordship.
Mediation will be petitioners and the petitioners they have settled. It's a joint petition.
Yes, your lordship.
But you settle before the mediation. If you don't agree, I mean, if you agree that as per the law, this cannot, it is.
Yes,
this,
your lordship,
it
for
can-
that, your lordship, the matter can be, your lordship, if the offense which is here, your lordship, the booked against the accused person, your lordship, if this offense is not against the society, my lord, the law is well settled, then in such case, the court can quash the matter, my lord.
So that's why instead of that,
Yes, your lordship, because
instead
even,
of that, it will take time. Isn't it?
your lordship,
Here the
even,
matter and all those things. So this listed for, it's not, have you seen the cause list?
yes, your lordship,
It's listed for a mediation.
yes, your lord, this is the issue, your lordship, what,
Decide in the mediation, we'll close it.
your lordship, how state can enter into an agreement with the petitioner, my lord?
It's not an agreement, mediation.
Yes, my lord, mediation, the conflict has to be, that if there are differences, that has to be settled, your lordship. But now, your lordship, since the party has already settled, now state is the state, your lordship, since it is prosecuted by the state, your lordship.
See, as a criminal petition or allowing or dismissal is one thing by the court. This is a special right for mediation.
Yes, your lordship.
So if you find that since they have been settled and as per the law it can be closed,
Yes,
their
your-
grievance can be closed. If you agree on that, this will be decided, then we'll close.
yes, your lordship. Here, your lordship, since they have settled, your lordship.
Why
we have-
not that there is a, I mean, disputed thing and all those things that therefore we are sending it when it is for disposal
Yes, your lordship.
of the matter.
The ultimate disposal will be by this court only, my lord.
Yes.
Yes, your lordship. So, since they have settled the matter, your lordship, we don't have any objection to
Well, let it-
matter to
this is
be.
listed it for mediation. We'll send it to mediation. You do that. Let the mediator file a report, place a report and we'll close that on that basis. If you don't agree that it cannot be allowed, right?
Yes, your lordship.
Then we'll see. Mediation will be between the petitioner and you, not within the petitioners.
Yeah, that is there, but your lordship, the guiding law is there, Lakshmi Narayan and all are there, your lordship.
Sir, even the service matter, It's a national mediation for nation, special drive, special mediation drive.
My lord, they have no against this petition, it can be disposed of today, my lord.
Heard Mr. So and so. T. Tony, learned counsel for the petitioners, and Mr. T. at learned additional public prosecutors for this. Next matter is listed for referral to mediation. As agreed by the learned counsel for the parties. As agreed to by the learned counsel for the parties. Mr. Whom any
Yes, my lord.
choice of mediator? Any choice of mediator?
No, my lord.
Will appoint Ninu, Mr. M. Ninu, Marco Ninu, learned counsel is appointed as mediator. Parties to furnish copies of the petition along with the documents be furnished to the learned mediator within 2 days. You will have to inform her. In fact, he may not know who is available in the court. Can you inform them? Inform him.
I can inform them. We can
Ah.
inform them.
You furnish both of you. I think he may not have that. You may furnish the copy within 2 days. The learned mediator to place the report on the next date. List after 2 weeks. You tell him that he's one of the panel. He's one of the mediators of the High Court for this, especially for this. Tell him you sit with them, sit with him, and he'll prepare the report and place before this. On that basis, you will decide.
My lord, your lordship, so far as your lordship, the mediation part, your lordship, has to be between the state and the other side, your lordship. That is there. But your lordship, if your lordship, state has no objection, if they have already settled the matter for disposing of the matter, your lordship, I think your lordship, it will in fact prolong the proceeding, your lordship. Again, we have to sit for the mediation and then.
The next date will.
And your lordship, and moreover, your lordship, we have to advance the argument basing on the settled law, your lordship. I cannot give consent.
See, mediation is not to have that. If you think that as per the law, I mean, he has the case, there need not be any kind of legal proceedings for arguing the matter and all those things. You agree to that, we'll pass that. If law doesn't permit for, I mean, settlement, you object to it. Then automatically this will be in a judicial system. Correct. Election petition, IE, 182.